today. Each one will be about 25 minutes in length. We won't take any formal breaks during the 2-hour program today, so if you need to take a break, feel free to get up and stretch your legs. I'm going to go ahead and introduce our first group. First up is Tracy Wolf and Kiera Powell, who are going to kick off our program talking about the use of artificial intelligence in employment. Tracy is a labor and employment partner in our Dallas office. She has extensive experience in employment law, complex commercial litigation, including technology-related products and services, directors and officers litigation, general liability, and just about everything else under the sun. Kiera is a labor and employment attorney in our Houston office. Her primary focus is investigative work and preventative counsel, but she also assists with litigation and has attended mediations, depositions, negotiated settlements. She routinely handles internal investigations, particularly those involving allegations of discrimination, harassment, or other civil rights violations. So with that, I'm going to turn it over to Kiera and Tracy.
Thanks, Kevin. We're glad to be here today to get the chance to discuss artificial intelligence. It's something that's really changing in the marketplace, and I think that Kiera can start off by trying to define artificial intelligence a little for everyone.
Thank you, Tracy. So artificial intelligence, or AI, is the theory and development of computer systems that are capable of performing tasks that historically required some type of human intellect. AI is basically the umbrella term. However, it encompasses several computer technologies. Some examples are machine learning, deep learning, natural language processing. And believe it or not, many of us have been using artificial intelligence for quite some time. A few examples that many of us use quite often are ChatGPT. I know that's a pretty popular one right now. And essentially how ChatGPT works is it takes a large language model and it generates text based off of comments or questions that are posed to the platform. So that's a new one that's been very fun for many of us to use. Another one is Google Translate. Google Translate is, it takes basically a deep learning algorithm and it's able to translate text from one language to another. Last one is Netflix. Now, I know many of us, Netflix is very near and dear to our heart. So Netflix uses a machine learning algorithm, and based off of past videos or contents or shows that you've watched, Netflix is able to make recommendations for other shows that you may enjoy.
So Netflix is starting to know a lot about all of us. They recommend movies, things we might like based on our preferences.
Absolutely. I know many of us are visual learners like myself, so I thought this chart would be a great kind of high-level explanation of how AI works. So as you can see, initially, data is input into an AI tool, right? And so the data can come from humans or algorithms. Based off of that data, the AI tool is able to process and analyze it, and from there, it's able to learn patterns. And these patterns allow the AI software to make recommendations. And ultimately, the recommendations allow the AI tool to perform a task for us. So as you can see, it's very important, the data that we place into the AI system in order to perform a task. And we'll talk about this a little bit more in our presentation.
Okay. And we're also interested in knowing about how artificial intelligence applies to our daily life. I mean, we already know about Netflix. I mean, that's shocking in and of itself. I know that customer service, a lot of times, whether it be on phone calls or interactive chats on the internet, there's certain prompts and things that just kind of come up automatically. It's kind of like magic, but these are based on these machine learning systems and anticipating what is going to be asked, what simple tasks are needed, and it's kind of shocking. What about other areas?
Yeah, social media is one where we have seen a lot of AI. I know if you're online shopper like myself, you get on the social media platform and all of a sudden you see all the ads for items that you have, searched. So basically those are algorithms and machine learning that is able to make suggestions for even users that you may know. So.
Yeah, it seems like every time I'm getting ready to go on vacation, I start getting ads for swimsuits and covers on Facebook. So that makes sense. I've also noticed it a lot in travel. For those that travel, a lot of times you are dealing with chat bots, and which we'll get into a little bit later, and other online mechanisms to recommend travel preferences and checking into a hotel. I mean, I'll say last night I checked into a hotel entirely without dealing with a human being. It's really getting strange these days, don't you think?
Absolutely. And along the same lines, vehicles, we're seeing AI tools being used for these new autonomous vehicles. I had a friend recently who went to San Francisco, and she told me that the vehicle that picked her up was completely driverless. So it was autonomous,
Would you get in a car without a driver?
I think I would.
You would?
Oh,
you
yeah.
would? I don't know if I'm quite there yet. It sounds a little daunting, but yeah, things are changing. I noticed another area, healthcare. I know for some time they've had mechanisms to assist healthcare professionals, such as dictation machines for physicians' notes. They now have automated means of completely organizing hospital files and medical information. It's becoming pretty formatted through the use of AI, which is taking up a lot of the simpler tasks, so to speak, that traditionally have been performed by humans.
Absolutely. And I've heard that soon these AI tools will be able to make full medical diagnoses.
Wow.
What do you think about that?
Yeah, I don't know. I mean, there's a lot of downsides to it. I know we're going to be discussing that a little bit later. I know another thing we've seen, and this is something that you were telling me about, security, video analytics. How does that work? Determining whether or not someone's in danger. I mean, machines are doing everything now. Can you tell me a little bit about that?
Absolutely. So the video analytics are able to basically pick up on behavior that could be a little bit human behavior that could be determined as abnormal or could pose a possible safety risk. So that's a great preventative measure.
Like for issues dealing like with workplace violence, the behaviors of people, that sort of thing. Absolutely. That is so unique. And so it's amazing how technology is progressing. How are these, and wrapping it back to, I mean, the thing that's most near and dear to both Kiera and myself is employment law. Bringing that back to employment law and how that relates and how that interacts with individuals in the workplace. Let's discuss how AI is used in the workplace.
Absolutely. So we're noticing a trend of employers are using various AI technologies in the hiring and recruitment process. We've been seeing companies have been using resume scanners. These resume scanners basically prioritize applications by keywords. So it's really unique. So if the employer posts a job listing, the resume scanner is able to look for keywords in the applicant pool of resumes. And if the resume has those specific keywords, then this applicant will be suggested to move to the next round of the interview process.
But sometimes software, it doesn't take other items into consideration. There's some risks with that, aren't there?
Absolutely, and we'll be able to talk a little bit more about that.
Yeah, we're going to talk a little bit about that in just a few minutes. Something else we're seeing is monitoring software. A lot of employers now have the ability to determine whether or not their employees are online and working. And I know that this became very significant during COVID. How do you tell that someone's actually online working? They do everything from monitoring directly people to just watching their keystrokes. And it's, there are a lot of questions that come up, and we anticipate, although there's not a whole lot in the law right now to address these sort of issues, that's something that we're going to see progressing, the ability, and if there are privacy concerns, what type of issues are going to come up. It's going to be very interesting in employment law in the years to come. Also, there's virtual assistants, chatbots. We've talked about that a little bit. I like, the concept of a chatbot. We're going to talk about that in detail. What about this interviewing software? Have you heard about that?
Yeah, so the interviewing software is pretty unique. It evaluates candidates based on facial expressions as well as body language. So an employer will upload a series of questions to an AI platform, and the applicant will have the opportunity to answer these questions and record their responses. And so the tool will essentially evaluate the candidate based off of language or speech recognition, and it will, suggest that this applicant should move to the next round. So it's very unique. They've been under scrutiny, so we'll continue to watch. Also, along the same lines, they have testing software. Testing software basically provides job fit scores for applicants regarding personality, aptitude, cognitive skills. And a lot of times the software tests applicants by providing testing questions or by providing games. And so the software will essentially grade the applicant based off of how the employer rates the ideal candidate, what criteria that they're looking for.
And that would be my question. How does the software determine what traits and characteristics are going to be applicable to a position? And how can they do that and do it in such a way that's neutral and doesn't raise issues for protected class characteristics?
Yeah, so the companies will they'll upload like the top characteristics that they're looking for. But I think as we'll talk later that there could be some possible risks with this type of software.
Yeah, I know there's some litigation right now that's dealing with some of those issues we're about to get into. Yeah, it's moving quickly. We've got a lot of room to cover right now. Wanted to talk just generally about, and a lot of this may seem obvious, but just generally the benefits of using AI in the workplace, with the caveat, that oftentimes there are other employment considerations which definitely need to be taken into consideration. Of course, using AI can result in increased efficiency and productivity. Simple tasks are always usually and historically performed by humans. A lot of these very simple tasks can now be performed by machines and computers. I think that the instant responses, the ability, it's kind of like we've become wanting instant gratification and instant responses to things. We're used to getting on our handheld phones and typing in things on Google and getting an immediate response. AI is really good about that. So it brings up efficiency issues and business issues that help businesses run more efficiently and without the human interface. Also, there's the concerns, though. I mean, because you are dealing with machines. Machines don't necessarily understand individuals and people. They seem to be developing personalities, which is kind of frightening. But machine learning can track a lot of this information. And what we're finding is that machine learning is really trying to mimic even emotions and mannerisms and expressions, using common slang, that sort of thing. Machines understand these things, and it's just kind of like they're collecting all this information in databases to use, and really, in a lot of ways, take over doing simple tasks that have traditionally been performed by human beings. And I mean, there's some good from it. Of course, it can reduce operational costs. It can make things more efficient, but also there are a lot of risks and a lot of potential for bias there.
Absolutely. So as we discussed earlier, AI relies on data to make its predictions. So if the data that is programmed into these systems contains biases, then there's a possibility that the output itself will also have a bias. There are three main sources that we've seen biases in the AI, and it's training data, through algorithms, and through humans. So training data is one of the most significant contributors to AI bias, because these programs learn from historical data over large spans of time. So if these, if the data contains if the data contains discriminatory practices, then oftentimes the output will also show some possible discrimination. An example of this would be AI software. There's been studies that AI software is able to produce images. So you can tell the software, please produce a image of a secretary. Now, according to the historical data, secretaries oftentimes were women. And so the output will show a woman based off of historical trends. Same thing applies for doctors or lawyers. If you ask the AI system to show us a picture of a doctor or a lawyer, through history, that was usually a older male. And so that is usually what the images will show today based off of AI. Algorithms have the ability to show biases because whether intentionally or unintentionally, the algorithm will suggest a result that could potentially show a bias. An example of that would be Meta has been under fire because it's been said that their job posting or ads will distribute to male users if they believe it is a predominantly male-dominated field, or if they believe that it's a predominantly woman-dominated field, then the ads will go to women users. So we've seen some litigation about that we'll talk about.
Just for clarification, now Meta, that's the same as Facebook, right? That's their current company. Yeah, I just learned that not too long ago, and yeah, it's amazing the ads that you see if you use that social media.
Absolutely, and also humans have an ability to impact the AI output based off of their biases, whether it's intentional or unintentional. If a human inputs data, they could input data based off their own personal beliefs. An example of this, it was a company that used AI software, and one of the employees put in resumes, and all of the resumes were male engineers. Okay, so they used the resume scanner. The resume scanner, went through the process, the applicant pool, and actually disqualified women applicants because the resume scanner noticed that all the resumes that were uploaded were men. And so we can see how, that could possibly be a gender discrimination case.
Wow. Well, we've referenced the law a little bit. Let's go ahead and start talking about what is going on and what is out there and what we need to be aware of, what our clients need to be aware of with regard to using AI in employment in the workplace.
Okay, and so we've talked a little bit about the fact that there's currently no federal regulations concerning AI. Now, this is brand new news. Actually, on October 30th of this year, hot off the press, yeah. President Joe Biden issued an executive order regarding safe, secure, trustworthy artificial intelligence. The purpose of this executive order was really to, it demonstrates that AI use can be great in the workplace, but it also has some challenges. So the order focuses on both procedural safeguards as well as substantive safeguards. And like I said, this is really hot off the press. There's been tremendous buzz around this executive order because it's the first of its kind. It's the first executive order that addresses the growing use and development of AI in the workplace.
And we note that there is no real federal guidance right now, aside from, and we've talked about the executive order, and that's helpful. That's a good start. We do have some states that have enacted some legislation to deal with these issues, including Illinois. They have what's called the Artificial Intelligence Video Interview Act. And it's got some requirements such as notice, transparency on how AI works, consent by the applicant, limits on distribution, and the duty to destroy upon request. Maryland has the facial recognition technology law. It prohibits an employer from using certain facial recognition services. And that's going to be a topic we're probably going to see all over the nation within the next several years, I'm sure. Finally, and this one's been in place since 2021. New York City has the automated employment decision tools, and this addresses some of the issues that Kiera has spoken about previously today. You know, these automatic tools, and the it's just implicit that bias could occur based on the machine learning. It's not that the machine is itself the software is exercising a bias. They're exercising biases based on the information that's fed to them and what they've seen. Whether or not it's intentional, I mean, these sort of things are going to be held, the companies are held responsible. And this is a raising issue that's coming up in New York now. And we anticipate that it's going to become more prevalent and probably a federal law too. Kiera, would you like to discuss the proposed American Data Privacy and Protection Act?
Sure. So the proposed American Data Privacy and Protection Act, it would have been the first federal data privacy law in the United States. It was actually approved by the Committee on Energy and Commerce on July 20th, 22. However, it failed to advance to the House and Senate floors. The purpose of the legislation was essentially to establish a uniform set of protections and rights for Americans regarding the use of their data.
So it's my understanding is that is being reformatted to hopefully come back in a different form, and maybe we'll see some guidance from the federal government on that.
Yeah, that'll be good to watch for.
Well, I know the EEOC has provided a little bit of guidance. Do you want to discuss that a little?
Yeah, the EEOC has made it clear that the use of AI in the workplace is definitely hot on their radar. In 2021, they announced the Artificial Intelligence and Algorithmic Fairness Initiative. In 2022, we also saw that the EEOC issued guidance cautioning employers on the use of digital software, algorithms, and the use of making employment-related decisions based off of AI tools. 2023, you know, they've issued their strategic enforcement plan for the years 2024 through 2028, and AI is high on that list.
It's kind of on everyone's mind right now. Well, we talked a little bit earlier about ChatGPT. I mean, this is something that I think a lot of people are just becoming aware of, and chatbots in general. I think ChatGPT is advertised as the artificial intelligence chatbot that knows everything, but does it. You know, these chatbots, they're computer software programs or web interfaces that they simulate human conduct. They can take a human conversation, either written or spoken, and interact like a human, which is kind of incredible and very interesting, but also very scary at the same time. These chat boxes have the ability to incorporate machine learning and come out sounding like natural human language. It's very human-like. And as earlier we discussed, the use of tools such as this, I mean, it's helps with efficiency, it saves time. There's unlimited resources there. And around-the-clock availability. Chatbots don't usually go on break. They don't have to sleep. They don't go out to dinner. They're also multilingual, which is something that I know a lot of people traveling have these apps now on their phones, and they have the ability to get a translation right there with them. So there's some wonderful aspects to it, but also many risks that we have to be aware of. As Kiera's discussed, bias, whether it be intentional or otherwise. Something else is the unintentional dissemination of trade secret and confidential client information. And I know particularly in the legal industry, that's something that we're watching very carefully. Once you feed something into one of these mechanisms, you don't necessarily have control of it. So it's something that has to be monitored. I see our time is really going quickly. We've had fun discussing this. Wanted to point out some of the litigation going on here. I let you tell a little bit about what we've seen out there recently.
Okay, so a really, really recent case would be the EEOC versus the iTutor group. This was actually the first litigation that the EEOC has pursued regarding the use of AI in the workplace. This was actually a company that was based in China. However, they had job postings in the United States for tutoring positions. And the EEOC alleged that their software automatically disqualified applicants that were women age 55 and over and men age 60 and over. And so the company actually settled for $365,000, and they paid out to over 200 applicants that were disqualified improperly. The next case that's pretty recent, so that we're continuing to watch, is the Real Women in Trucking versus Meta Platforms. This is a case where a nonprofit group that advocates for women truck drivers filed a class action charge with the EEOC against Meta, and they essentially alleged that Meta software routinely discriminates against women and older people when deciding what users are able to receive employers' job ads on Facebook. The last one that's fairly recent is the Derek Mobley versus Workday. This is a case where a plaintiff is an African-American gentleman. He claims to be disabled and over the age of 40. He claims that the Workday software disproportionately disqualifies applicants who are African-American, disabled, and over the age of 40. So these will be cases that we want to continue to watch.
And I think we'll probably see a lot more. But we've noticed we've had a lot of fun here today. I think our time is coming to an end. We will be available online afterwards to answer any questions. I hope you've enjoyed the presentation. We see artificial intelligence as the new horizon. We are carefully monitoring laws and litigation that will affect our clients, and any questions about it, we'd be happy to discuss. Thank you for your time today.
Thank you.
Thanks, Kiera and Tracy. Yeah, that's a fascinating topic. I think we're just going to continue to see more and more legislation, more and more guidance from the EEOC, more litigation on this issue. So it's definitely going to be something that us and our clients need to keep an eye on over the coming years. Next up, we are going to have Andrew Caton in our Dallas office talk about arbitration agreements. But before Andrew starts, we're going to go to our first poll question. I'll give it just a second to get pulled up. Okay, first poll question. How will you use artificial intelligence to assist you with the holidays this year? A, B, I'll utilize Google and Amazon AI tools to help with gift ideas. C, apparently there are AI apps out there that'll actually help you decorate the interior and the exterior of your house for the holidays. Or D, I don't need any more robots in my life. So go ahead and give the audience a few seconds to submit their answers. See them coming in. Okay. And let's see. What's the poll looking like? Have a few more answers filtering in. And it looks like 56.2% of you said D, I don't need any more robots in my life. I feel you guys. I think other than my Roomba at home, I'm going to try to stay away from as many robots as I can. So with that, we'll go ahead and transition over to Andrew. Like I said, Andrew is in our Dallas office. He is a labor and employment attorney focused primarily in the litigation space. He regularly advises clients across multiple industries regarding discrimination and retaliation issues, but also complex commercial issues such as trade secret misappropriation, breach of contract, breach of fiduciary duty, tortious interference with the employment relationship. If it touches employment, Andrew's your guy in Dallas. So with that, I'll go ahead and transition it over to Andrew.
Thank you, Kevin. Again, Andrew Caton, it's a pleasure to be with you here this morning. And so good morning, or wherever you're at, good evening, good afternoon, whatever the case may be. It's certainly a pleasure to join you. I'm going to talk to you guys today a bit about arbitration agreements and changes that have been coming down the pipe for the last year or two relative to their enforcement and enforceability. So before I get too far into this, I guess I'll start with the general topic of why am I talking about arbitration agreements? After an exciting topic on artificial intelligence, I'm sure that most of you are sitting there in your best Homer Simpson voice saying, arbitration agreements? Boring. Hello, what are we doing? Well, arbitration agreements are really an important facet of labor and employment work. And it really is a very significant aspect of litigation that relates to employment claims that employers bring against their employers. And so I'd be remiss if I did start in a little over a year from now. February 12th, 2025 will be the 100th anniversary of the enactment of the Federal Arbitration Act. For the first 2/3 of the life of the FAA, that really didn't have much effect on employment agreements with respect to employers and their employees by and large. But all that changed in 1991 in the case of Gilmer versus Interstate and Johnson Lane, where a 62-year-old employee had been let go. He brought a claim of age discrimination against his employer, and the employer sought to compel arbitration based on a mandatory arbitration agreement. The Supreme Court basically said that, yeah, these are the kinds of claims that are enforceable. And what it really kind of did was it brought a new phase and a new way for employers to mitigate and manage their risk with respect to their employees, bringing claims associated with their employment. Just to give you a little bit of context, in a 2018 Economic Policy Institute study, a full 54% of non-union private workplace employers had some form of mandatory arbitration agreement in effect in their workplace. So over half of employers in the United States have these kinds of agreements in place. Texas and California are among leaders in the race, north of pretty close to 68% of employers have those kinds of mandatory arbitration agreements. And surprisingly, or maybe not so surprisingly, but North Carolina actually leads the pace at 70%. The opponents of arbitration agreements, I should say that arbitration agreements are such an important and a common factor in the employment space that what happens with litigation associated with surrounding arbitration is going to dictate a lot of what employers can and cannot expect and how they mitigate and manage their risk. Opponents of arbitration claim and assert that by being forced into a mandatory arbitration agreement, that they are significantly less likely to bring claims against their employer that they might otherwise vindicate if they could proceed in a court of law. They cite the studies that suggest that employees tend to win on a reduced percentage in arbitration as opposed to federal court, and that even when they do win, they typically receive less money than they would otherwise expect to receive in court or from a jury. And so with those regards, there's always there's a fairly constant battle from employees and their attorneys trying to knock back at the protection of these arbitration agreements and forced arbitration. The Supreme Court, for the first, like I said, it was 1991 when the Supreme Court had initially discussed that, yeah, these are enforceable agreements and employers can compel arbitration in these instances. And for the 30 plus years since then, the Supreme Court has consistently doubled down on that proposition, thwarting all efforts from multiple sides to try and reduce the applicability of the Federal Arbitration Act and otherwise compel arbitration for employees. And just in the last 2 years, we're starting to see finally, I shouldn't say finally, but we are seeing some, let's just say the courts are starting to waver a little bit, and maybe the legislature as well, in terms of just how far these protections should go to employers and how much additional power they should give back to employees with respect to these arbitration agreements and trying to pursue them in litigation. We'll first start with talk generally about the three kind of areas of arbitration enforcement that we're going to talk about. The first relates to sexual assault and sexual harassment claims. The federal Congress had enacted and Biden passed in 2022 the sexual assault and harassment. There's the ending of forced arbitration and sexual assault and sexual harassment Act, otherwise sometimes referred to as the EFA, the EFAA. I'll just refer to it as the EFA for now. I will advise that apparently there is a, what is it called? There is another EFA Act called the Expedited Funds Availability Act. That's not what I'm talking about here. This relates specifically to an effort by Congress and by the president to give some power surrounding these forced arbitrations back to employees. Next topic I'll go into will be, well, who gets to decide whether or not these arbitration agreements are enforceable and can compel arbitration as opposed to proceeding with those claims in court. And then finally, we'll talk a little bit about waivers of arbitration rights and how in certain instances, a party that wants to compel arbitration could possibly waive that right to arbitration if they proceed a certain distance down the road in litigation. So first, I guess I'd initially like to discuss, as a result of largely the hashtag #MeToo movement, we're seeing quite a bit of rights being, in power really being given back to victims of sexual harassment and sexual assault in the workplace. Under the expedited, I'm sorry, not the Expedited Funds Availability Act, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. What it basically does is it says that any mandatory arbitration agreement that relates to a claim of sexual assault can no longer be forced to go to arbitration. Certainly the party can pursue that option if they wish, but they can pursue that claim in court if they're so inclined to. Now, what this particular law relates to, because we have all manner of state, local, federal, tribal laws that relate to sexual assault, sexual harassment events. This law specifically applies to, any dispute regarding that is alleged to have constituted sexual harassment or sexual assault under applicable federal, tribal, or state law. And just as, I guess, a piece of anecdotal evidence regarding sort of this idea of giving power back to victims of sexual assault and sexual harassment, in Texas, I talked about this just about a year ago in a similar experience regarding the Texas enactment of a change to its Texas Labor Code in September of 2021 about defining sexual harassment in the workplace. It also expanded the definition of an employer and who is subject to claims for what kinds of employers are subject to claims for sexual harassment, as well as the employer's duty to mitigate and investigate claims of sexual harassment, and expanded deadline to file a charge of discrimination from the 180 days under Texas law up to 300 days, which closely mirrors federal law. So with that context in mind, we're seeing that in many respects, with respect to sexual assault, sexual harassment, that power is being given back to victims to pursue those claims in court than where they had previously been. Now, under the EFA, a couple of things. It's only recently been enacted, 2022, March 3rd, 2022, and it applies to all claims that occurred on or after that date. So it's not retroactive. So if there are claims of sexual harassment or assault that occurred prior to that date and is going to be subject to a mandatory arbitration agreement, then the court's going to continue to go ahead and enforce that, and the victim would have to pursue his or her claim through arbitration. I'll talk a little bit about some of the different cases. There are only a handful of cases that have been decided, a couple in Texas. These are all district court opinions. They've not reached the appellate level yet. But I'll talk about the accrual issues that surround assault claims, as well as and harassment claims, as well as the pleading requirement. These are issues that have been litigated in the Texas courts and several others. The first one is in Marshall versus Human Services of Texas. This case, a plaintiff alleged that between 2015 and 2018 that she was subjected to some severe sexual harassment and retaliation actions by her employer in violation of Title VII and Chapter 21 of the Texas Labor Code. Now, all these acts had occurred between 2015 and 2018. This matter didn't really even proceed to court until right about the enactment of the statute. Now, the plaintiff in the case had actually agreed to go ahead and go through with arbitration. The employer filed their motion to compel, so they went to arbitration. In December of 2022, the arbitrator issued a take-nothing judgment in favor of the employer. The employer subsequently filed a motion for entry of judgment about that, and it was only at that time that the plaintiff make this claim that the EFA Act precluded entry of the judgment and that she should be able to pursue her claims in court. Quite wisely, the court just basically said, look, these things happened between 2015, 2018. The law is very clear. It's not retroactive. None of your claims occurred on or after March 3rd, 2022. As a result, they went ahead and granted the employer's motion for entry of that judgment. And again, what the court said in that particular case was that the plain language of the EFA Act, however, explicitly states that it applies only with respect to any dispute or claim that arises on or after the date of the implementation of the Act. A follow-up case was Watson versus Blaze Media. I don't know if you're familiar with Blaze Media. It's a Texas-based, it's sort of a streaming podcast type, or I guess a podcast service. And in that particular instance, a host of the show, a co-host of the show had claimed that beginning in approximately 2021, she started on the show and her co-host was subjecting her to pretty severe forms of sexual harassment, and religious discrimination as well. And in that particular instance, some of the acts of harassment had occurred prior to the enactment of the statute. And when the employer sought to compel arbitration in that particular case, the employer's argument was just that look, some of these acts occurred prior to the enactment of the law, so she should be compelled to go to arbitration in these claims. And the court ended up basically stating that because there was a continuing nature of these harassing acts, and that many of these continuing acts occurred after the date of enactment of the EFA, that basically constituted a hostile workplace environment, and that under Title VII, hostile workplace claims is a sort of a continuing violation. And as long as the last act had occurred after the enactment of the statute, then in that particular case, she could proceed in court, and the motion to compel arbitration was denied. The next issue that's been litigated under the EFA is the pleading requirement. And essentially what this relates to is whether or not, one concern that I think raises to me in that because the EFA applies only to claims of sexual assault and sexual harassment, that a person that might have a pretty good claim for a racial discrimination or an age discrimination claim might try to bootstrap a sexual harassment type claim on top of it in order to get this into the courts instead of being compelled to arbitrate. And so an important, I think, issue that could possibly be coming up down the road is that we see these instances where rather implausible occurrences of sexual harassment are added onto these claims for racial or age discrimination to keep it in court as opposed to arbitration. But that issue hasn't been specifically litigated yet. What has been litigated are other pleading requirements. I need to go to what's called plausibility. And all that's required of a plaintiff is that they plead facts that plausibly lead to a claim that they're talking about. And so the first case that was litigated that I brought up is called Yost versus Every Realm. In that particular case, this is a New York case. In that particular instance, a woman claimed that there was a pervasive sexual hostility and overtones in the workplace. And despite being given several opportunities to amend her complaint, because it's all in federal court, despite several opportunities to amend, she still, that even though, yes, all of these sexually related occurrences happened in the office, what she failed to do was basically state that all of that kind of harassment occurred because of her sex, and because she failed to make that connection that these occurrences happened because of her sex, it was implausibly pled under Title VII, as well as New York City and state codes about the same matter. And so in that particular instance, the court said that she did not plausibly claim a sexual harassment case, and the EFA Act did not apply. The next plausibility goes back to the it goes back to the Watson versus Blaze Media case. In that particular instance, the plausibility issue is whether or not the plaintiff in that case had pled that she was an employee as opposed to an independent contractor. The employer basically tried to say that in that particular instance, she was an independent contractor, and as an independent contractor, she couldn't bring these claims based on Title VII and would have to go through arbitration anyway. But in that case, the court went ahead and concluded that just basically on a plausibility standard based on factors that relate to differences between employees and independent contractors, that the plaintiff in that case was at least plausibly pled that she was as an employee, denied the motion to compel arbitration, and the case is going forward. And Judge Boyle in that Watson case had basically stated that at the pleading stage, the plaintiff need only allege those facts, enough facts to support the conclusion that she was an employee. The next issue that we'll talk about regarding enforcement of these sorts of agreements is who gets to decide. Does the court get to decide, or does the arbitrator get to decide? And like all good legal questions, the answer is, well, it depends. Generally speaking, that the court will always have the ability to decide the threshold question of, is there even an agreement in place? Is there a contract? And that goes to contract formation. So for example, and when we think about, at least legally, in a contract, was there a meeting of the minds between those parties to have a contract? If the court decides no, then in that particular case, then the arbitration agreement gets tossed out and the claims will proceed in court. If, however, the court decides that, yeah, there is an agreement here, then we look to whether or not the arbitration agreement itself explicitly states one way or another. In that particular instance, in some particular instances, the issue of enforceability might boil down to a lot of employees will claim unconscionability, right, as a way to get around the arbitration requirement. They'll say that an arbitration agreement is unconscionable, but that goes to enforcement of the arbitration agreement and not the formation of the agreement. And the courts have said that when that is the case, if in a particular instance, an arbitrator may be able to decide that issue. Cases that are involving here, we talk about what, first of all, we'll look at what does the arbitration agreement say. If the arbitration agreement itself gives the arbitrator the power to decide whether or not a particular issue is arbitrable, then the arbiter will have that ability to do so. And the courts have also said that where the arbitration agreement essentially encompasses those rules of specific arbitration providers, such as the AAA or JAMS, then in those instances, it's basically implicit that the arbitrator gets to decide the issue of arbitrability. And likewise, in one of the cases I cite up here, Michael versus Opportunity Financial, in that case, the arbitration agreement actually gave power to the court to go ahead and decide the issue of arbitrability. I see my time is starting to run up here, so I'll try to accelerate just a little bit. One court said that the parties cannot delegate disputes of the existence of the agreement. And so we'll skip past that. The next one is and the final issue is the waiver of arbitration rights. In this particular instance, previously under Fifth Circuit law, whether or not an arbitration agreement could be enforced we'll step back. The circumstance is a party has a known right to go to arbitration, but they don't do it. They proceed with litigation, and maybe they go down the road and they decide that, you know what, I don't want to do that. I want to go to arbitration instead. In that particular instance, under old Fifth Circuit law, what used to be the case was that a person that wanted to keep the case in court would have to argue that not only was there a waiver of the right of arbitrability, but that also that particular person suffered some sort of prejudice in the process. And in the 2022 case that went to the Supreme Court, the court went ahead and said that prejudicial requirement was essentially like adding on a substantive or a procedural rule under the Federal Rules of Civil Procedure, and the Federal Arbitration Act simply didn't grant them that sort of power to do so. So as a consequence, the prejudicial requirement to whether parties waived arbitration rights is no longer required. And so while the old standard was that a party, that they must have substantially invoked the judicial process and suffered prejudice, is now just that they substantially invoked the judicial process. And so that's sort of where it's been left off. There is a more recent Texas District Court case that talks about that as well, and the order is basically in line with what the Supreme Court says, that the prejudicial requirement is no longer required. So I'll go ahead and try to wrap things up, taking a little bit of extra time. But we've talked a little bit about how courts and how sexual assault claims and sexual harassment claims are being treated in the arbitration space. Who gets to decide whether a case is subject to arbitration and how those decisions get to be made, as well as whether or not there's been a waiver of rights under arbitration. So with that being said, I appreciate your time. Again, these are paramount issues because so many cases and so many employers have arbitration agreements in place that it really is a powerful tool in helping them manage their risk. So thank you.
Thanks, Andrew. Yeah, another important and developing topic for sure. I feel like my clients always struggle with is arbitration the right thing? Is it fair for the employees? Is it more beneficial for us? So anytime I have a question about arbitration agreements or enforceability, I always reach out to Andrew because he's our go-to guy on that. So with the conclusion of Andrew's remarks, we'll transition now to our second poll question. Let me have that pulled up. And second question, your family is in a dispute about where to host holiday celebrations. Your mom and your sister have both signed arbitration agreements deferring any dispute to binding arbitration, but your dad refuses to sign and says he won't celebrate anywhere except for at his house. Can an arbitrator make the decision for your family as to where the holidays will occur? So first there, A is yes as to everyone, even though dad refused to sign. B, no as to dad, but yes as to mom and sister. C, maybe, it depends on other facts. Or D, tell dad to stay home while everybody else goes to Cancun for the holidays. So we'll give everybody a few minutes to get their answers in, or a few seconds, before we transition over to our next topic. We have some results filtering in. Give you all a few more seconds. Make sure everybody has a chance to participate. Okay. It looks like we've got a close tie here. It looks like, or almost a tie. 31% of you said B, 39% of you said C. Both of those answers are probably right answers. So it would be hard to force Dad to arbitrate if he didn't sign an arbitration agreement. But there could be other facts that could come into play that might change the outcome of that issue. So with that, we're going to go ahead and turn over to our third presentation. Aisa Maldonado and myself from our Austin office are going to talk about legal challenges that we're seeing to corporate diversity, equity, and inclusion programs. Aisa is a labor and employment attorney in our Austin office here with me. She assists clients with a variety of L&E matters and helping them stay in line with local, state, and federal regulations. Her practice primarily focuses on preventative counsel. However, she does also represent our clients in litigation matters at the federal and state court levels and through mediation. So with that, Aisa, I'll turn it over to you.
Thank you, Kevin. So today, Kevin and I are excited to talk to you about some legal challenges we've been seeing to corporate DE&I programs. Throughout the course of this segment, we're going to be talking about the current state of the legality of these programs, recent challenges to the programs, and some practical advice for employers to take away from these challenges that we're seeing. So first, I want to broadly define what diversity, equity, and inclusion is. And these are three values that are closely linked, and they're held by many organizations that are working to be supportive of different groups of individuals, which include people of different races, ethnicities, religions, abilities, genders, and sexual orientation, to name a few of the protected classes. Now, over the past several years, organizations have made significant investments into their DE&I programs, which we've seen have led to improved workplace climates. These investments are largely the result of businesses seeing the benefits of incorporating these programs, which can include higher productivity, better financial performance when employees are more engaged in their jobs, improved employee engagement, improved employee retention, and increased innovation, creativity, and problem solving. Conversely, employers have also seen the negative effects of not investing in diversity, equity, and inclusion initiatives. This has included negative financial impact, negative public perception, especially in the age of social media where word of mouth is so big. We're seeing people boycotting different organizations due to lack of diversity initiatives. It could also include missed ideas and perspectives, which could lead to more homogenous environments, and prospective employees may not feel as welcome or represented in the workplace, which is a really important point because a recent survey that was run by Ernst & Young actually found that about 63% of the respondents across all generations feel that DE&I initiatives are one of their priorities, especially when they're looking for jobs. So not investing in DE&I initiatives could result in maybe not retaining the talent that you want and having a smaller pool of employees to choose from. However, we have seen in recent court decisions these programs being called into question, and we're seeing challenges to these efforts. And we're going to discuss throughout our presentation kind of what we've been seeing and things that employers can do and things they should be keeping in mind in order to stay in line with federal and state laws. And we're seeing challenges to these. The case that actually added a lot of fuel to this conversation around the legality of corporate diversity, equity, and inclusion programs was the Students for Fair Admissions versus the President and Fellows of Harvard College. On June 29th of this year, the U.S. Supreme Court issued a decision that upended about 40 years of precedent, which permitted colleges and universities to use race in a limited aspect in higher education admissions. And the Supreme Court decision was actually two cases that were consolidated into one for the purposes of the Supreme Court's written opinion. So we have the Students for Fair Admissions versus Harvard, and also the Students for Fair Admissions versus University of North Carolina, which were companion cases. In Students for Fair Admissions versus the University of North Carolina, The plaintiffs alleged that UNC's consideration of race discriminated against both Asian American and white students, requiring them to score significantly higher on the grade point scale and also achieving higher test scores in order to be admitted in relation to their counterparts. And in that companion case, Student for Fair Admissions versus Harvard, the plaintiffs similarly alleged that the consideration of race in the admissions process was an attempt to impose illegal race quotas that discriminated against Asian American applicants, making it harder for them to be admitted to these universities. In these cases, the plaintiffs looked at statistical data and they looked at the overall population in the US, and they saw that in the recent years, the Asian American population in our country has increased, and the number of these applicants has also increased in these universities. However, they also saw that the amount of this demographic that was being admitted was remaining relatively stagnant. And as a result, they ultimately felt like they were being disproportionately denied admissions to these universities. So the Supreme Court in these cases held that the admissions processes at Harvard and UNC were both in violation of Title VI of the Civil Rights Act, and with respect to the University of North Carolina as a public institution, also violated the Equal Protection Clause of the 14th Amendment. And the Supreme Court outright rejected the use of race-conscious admissions in higher education and reasoned that affirmative action in admissions lacks sufficient measurable objectives, involves stereotyping, and lacks sufficient endpoints. However, the Supreme Court did note that universities would not be prohibited from considering race in the context of its effect on an individual. So for example, if an individual writes in a college essay that, by virtue of their race, they were encouraged to apply for a certain position or hold a certain leadership position, the university just cannot say that, by virtue of them being Hispanic, for example, that characteristic in and of itself, you cannot solely admit them based on because they're going to make the university more diverse. You have to relate it to the contributions that they are going to contribute to the university and things of that sort. So while this decision is not applicable to corporate employers, we have certainly been seeing that there have already been effects on corporate DE&I efforts, with extra efforts being made to ensure that programs are in compliance with federal and state law. So following the court's decision in Students for Fair Admissions, the state's attorney general in 13 states sent a letter to Fortune 100 companies calling into question DE&I programs operated by these private employers. And in addition to states' attorneys generals, we're also seeing individual legislators also sending these similar type of letters challenging corporate DE&I programs. So for example, Senator Tom Cotton in Arkansas sent a letter to 51 law firms citing civil rights laws that he believes these firms and their clients may be violating by maintaining these DE&I programs. In Senator Cotton's letter, he stated that to the extent these law firms continue to advise clients regarding DE&I programs or operate a DE&I program of their own, both the law firm and the client should take care to preserve relevant documents in anticipation of potential investigations and litigation. And we're seeing these threats, as I had mentioned prior, that organizations in the past few years have really made these investments to DE&I initiatives in an effort largely to address historical inequities related to race, gender, and other protected characteristics. However, law firms are not the only organizations that are being warned. Over a dozen Republican attorneys generals from states such as Iowa and South Carolina have also sent letters to Fortune 500 CEOs cautioning their use of race in both hiring and recruiting practices. And we're seeing this a lot in diversity internship programs, diversity apprenticeship programs, leadership programs that are exclusive based off of minority status, racial minority, or by virtue of being women and things like that. So in addition to the letters by these elected officials, the Equal Employment Opportunity Commission has also contributed to this conversation. Within hours of the SFFA decision, the Equal Employment Opportunity Commission's commissioner and chairman both offered their initial views of what they thought this decision's effect would be on corporate employers. And the chairperson actually, her view was that corporate DE&I programs are still very much legal. Employers still are allowed to have these programs and really implement diversity initiatives and actually encouraging that, while on the other hand, the commissioner held a separate view and said that this should prompt these companies to start auditing their DE&I initiatives, and they should really be taking a look and making sure that they are remaining compliant with federal and state law. She actually gave specific examples in her opinion that race-based mentorship programs, race-based hiring practices, race-based promotion considerations, and race-based like pipeline programs all already may be running afoul of federal law. So employers need to be extra vigilant and aware of that moving forward to avoid any challenges to those programs. So now you may be asking, what is the Student for Fair Admissions decision's impact on employers? So the Students for Fair Admissions decision has no precedential impact over private employers operating under Title VII. And this is because the Equal Protection Clause applies only to federal and state actors, and the protections from discrimination under Title VI apply only to recipients who receive federal funding from the government. And well-structured DE&I programs do not run afoul of any federal, state, or local discrimination laws. And this is primarily because race-based decision-making in the workplace has never been lawful. Unlike in higher education, in the employment context, affirmative action that involves racial or gender preferences to achieve diversity has never been lawful. And under Title VII, race or gender conscious affirmative action programs by private employers are unlawful in the absence of some remedial purpose. So although the Supreme Court has now opened the door to and made more likely future legal challenges against private employers' DE&I efforts, it is still legal for employers to promote these initiatives. And now we're going to hand it off to Kevin to talk about these challenges.
Thanks, Aissa. Let's see if I can figure out how to do this. There we go. So yeah, we'll shift now, like Aissa said, and talk a little bit about the sort of challenges that we've been seeing to corporate DE&I programs. So, despite the fact, like Aissa just relayed, that the EEOC chairperson stated that the SFFA decision does not address employer efforts to, foster diverse and inclusive workplaces through DE&I programs, and that it, the quote from her was that it, quote, remains lawful for employers to implement DE&I programs. Like Aissa said, we're still seeing a bevy of challenges come through, some before the SFA, I keep butchering that, but SFFA decision, but certainly a lot more after. And these challenges primarily fall into two categories. The first one are shareholder derivative claims or shareholder derivative actions. And the second ones are claims of reverse discrimination. So in the next few slides, we'll walk through both of these types of challenges, and as well as some of the other trends that we've been seeing concerning these sort of efforts. So what is a shareholder derivative action? One of the duties of a company's board of directors is to pursue litigation against those that the board believes have done things to harm the company. But oftentimes, if there's instances where directors decide where the board decides it's not appropriate for whatever reason to pursue the claims, it is possible for an individual shareholder to sort of step into the company's shoes and sue on behalf of the company for harm that they believe is being caused to the company by a third party or the company's board or company policies, whatever it might be. State and federal laws typically require that a shareholder show that first he or she approached the company's board of directors to bring the problem to their attention. And if the company's board decides not to pursue the claim, then that could potentially give the shareholder an opportunity to bring one of these derivative claims. I think the example that we've heard most about in the news over the past year or so is the Starbucks case that's referenced there in the second bullet point. So in March of 2022, the American Civil Rights Project published an open demand letter to Starbucks Board of Directors on behalf of the National Center for Public Policy Research, essentially demanding that Starbucks retract its DE&I initiatives, its programs, its DE&I policies. Specifically, the letter complained about alleged goals by Starbucks to achieve a certain percentage of minority representation, both at the corporate level and at its retail and manufacturing facilities by 2025. They wrote the letter to the board. The board wrote back in July of 2022 to the ACRP and said, we've looked into your letter, we've looked into the issues you've raised, but we find that it's not in the company's best interest to retract these DE&I initiatives. So the next step was, a month later in August of 2022, the ACRP filed a lawsuit on behalf of the center against Starbucks and its board and Howard Schultz, its founder, essentially trying to get an injunction from a court that said Starbucks could not further promulgate or keep these sort of programs enacted. They also sought damages for what they allege was the diminution in the value to the stock that they owned in Starbucks. So that was August 2022. August 2023, about 3 months ago now, a federal district court issued an order dismissing the lawsuit, finding that these were not issues for the court to decide. These were public policy issues that should be decided by legislators and the companies themselves. So it found that this was not a good claim against Starbucks and dismissed the lawsuit. The other category of claims or lawsuits that we're seeing in this space are these reverse discrimination claims. Reverse discrimination occurs when members of a historically advantaged group, usually white males, claim that they are discriminated against based upon their protected characteristics, the fact that they're a white person or the fact that they're a man instead of a woman. Both the EEOC and federal courts have recognized that reverse discrimination claims can be actionable in certain circumstances under Title VII. And really the biggest case that we saw in this space most recently is the last bullet point there you see on your screen, the Duval versus Novant Health case out of North Carolina. In that case, Mr. Duval was a white male marketing executive, and he claimed that he was fired from his management position because he was a white male, and the company had DE&I goals to diversify folks in management positions. So at trial, he presented evidence of the DE&I programs, what they said, what the policy said, and he also put forth evidence of not only him losing his job, but other white male managers that had job duties taken over either by women or employees of a different race. The jury in that case found for Mr. Duval and actually awarded him over $13 million, $3 million in actual damages and $10 million in punitive damages. Now, that punitive damage award was reduced by the court to $300,000. The actual, verdict or judgment was just over $3 million, and it's on appeal now, and it's going to be heard, I think, in December. But these are very real claims. Obviously, there's very real potential liability associated with them. We've also seen claims asserted against American Express and AT&T, making similar allegations that employees were either discriminated against through DE&I programs or that they were retaliated against after they raised concerns about DE&I programs. It's definitely, like Aisa indicated, this is an increasing trend. We're seeing more and more of this. I think with the rise of sort of the anti-wokeness activism that's contributing to more and more of these sort of claims being brought either in court or through an administrative agency like the EEOC. One advocacy group has been particularly active in this regard. It's the America First Legal Foundation. They've sent a variety of letters to corporate employers, or to the EEOC actually, complaining of corporate employers' DE&I programs. I think last I looked, they'd sent like 15 letters or so in the last year. The letters, they're all a little bit different because companies' DE&I programs are all a little bit different, but in general, they all allege that these companies, they're complaining to the EEOC that these companies are implementing allegedly discriminatory DE&I programs in violation of Title VII, and then they're requesting that the EEOC commissioners file a commissioner's charge, basically EEOC versus these companies, based on these challenges they're raising to diversity, equity, inclusion programs. The EEOC has not done so yet. Most recently, the AFL sent a letter on November 2nd, less than a month ago, to the EEOC asking them to investigate both NASCAR and NASCAR's partner Rev Racing, where they have a diversity program to encourage minority drivers to get these opportunities to drive NASCAR vehicles. I think, historically, a lot of NASCAR drivers have been white males, right? And so they're trying to promote diversity in their organization. The complaint that AFL sent into the EEOC targets, the diversity program, saying that, this is not fair. It's giving a leg up to aspiring drivers and crew members who are, not white males, and they're asking for the EEOC to put a stop to it. AFL has also filed, I know we heard earlier about Meta in the artificial intelligence space. I guess just because they're such a big company, they're often a target. But they filed a lawsuit against Meta alleging that it conspired to put this racially discriminatory apprenticeship program in commercial film production forward. They filed a lawsuit there. That was filed in September of this year, so it's just getting started. But in essence, they allege that this program that was put into place, again, gives a leg up to minority or women candidates that white male employees are not getting the benefit of. But it's not just NASCAR or Meta. I've got a list there. Mars, Kellogg's, Starbucks, like we talked about, Morgan Stanley, McDonald's. I think Anheuser-Busch, Hershey Company, I know, has also received similar letters. So it is definitely an increasing trend, and I think it's something that we're going to see more and more of over the coming years. So with that, I'm going to turn it back over to Aisa, and she's going to talk about sort of some of the practical things employers can do to protect themselves from these sort of things.
Thank you, Kevin. So with all this information that we have given you, you may wonder, well, what does this mean for employers? So despite the recent challenges to DE&I programs, employers can continue to increase diversity in their workforce and set aspirational goals with respect to DE&I without running afoul of federal, state, and local anti-discrimination laws. However, employers must be careful when developing, communicating about, and implementing DE&I programs to ensure that they are not engaged in any impermissible discrimination. Employers should also take inventory of their DE&I communications, initiatives, mission statements, policies, programs, resource groups, and the like, and audit them to confirm that they are operating within the current laws. I wanted to take some time to talk about and give examples of what are some permissible DE&I programs. So, for example, a mentorship program open only to women and historically underrepresented groups would be an example of an impermissible employment initiative. On the other hand, a permissible employment initiative would be a mentorship program open to all employees, but women and historically underrepresented groups are highly encouraged to apply. Another example would be an employee resource group only open to employees that identify with a certain protected class. So for example, having an employee resource group for Hispanic employees, if you don't allow other races and underrepresented groups or the majority to at least sit in on meetings, attend different events, that is an example of an impermissible employment initiative. And you need to make sure that these employee resource groups are also open to other underrepresented groups, allies, and such. And finally, another example would be a impermissible hiring quota, which would look like a hiring policy with the goal that is set at hiring 40% women and 30% racial minorities, where a permissible initiative would be a company hiring policy with no set numerical goal and only states that the company is committed to equal employment opportunity and has set aspirational goals to increase diversity in the workplace. So now we're going to look at some practical tips for employers on how to make sure that your diversity initiatives are not running afoul of any anti-discrimination laws. So as I spoke about earlier, one of these major ones is to avoid using quotas when setting hiring or advancement goals. And this isn't only for hiring employees, but it's also for promotions. The second one is ensuring that you define diversity broadly. You don't want to just restrict those protected class to the 6 traditional ones, such as race, gender, sexual orientation. You also want to include things such as socioeconomic status, veteran status, parental status, and disability. And you also want to create mentorship pipeline programs and employee support groups open to all employees, as I previously mentioned. An important one is to also continue to provide anti-discrimination training and anti-harassment training. This will help reduce the liability for accusations of unfair employment practices. It helps prevent workplace misconduct, and having a formal reporting structure can also help prevent illegal activity from becoming a bigger issue if it already is one. You also want to continue to carefully review internal and external communications related to diversity, equity, and inclusion. And you also want to make sure you're taking all complaints of discrimination seriously, and this includes reverse discrimination. So upon a complaint, you may want to, or rather you should, institute a prompt investigation, make sure you're retaining documentation related to an employee's complaint, and importantly, if you find evidence of discrimination, you want to ensure that this discrimination stops immediately, correct any effects of this discrimination, and prevent it from happening again. So I'm going to end this presentation with just a little bit of a conclusion of what we've discussed. So as I mentioned at the beginning of our presentation, the Supreme Court's ruling in Students for Fair Admissions does not immediately affect corporate DE&I programs. Title VII has always prohibited employers from making employment decisions based on any protected characteristic, which has not changed in light of the Supreme Court's recent decision. And any diversity, equity, and inclusion initiatives in the workplace should continue to avoid making any employment and hiring decisions based on the applicant or employee's protected characteristics. And one last remark that I'd like to leave you with is that it is important to remember that lawful diversity initiatives should be designed to expand opportunity for underrepresented groups without negatively impacting those opportunities for the majority. And now I'm going to hand it back to Kevin.
Thanks, Aisa. Yeah, another fascinating topic. I think something else that we're going to see a ton of activity on in the next, probably 2, 3, 4 years. A hot topic for sure right now. Very politically charged too often. So with that, we're going to move on to our third poll question. Do we have that pulled? Can we pull that up? Okay. Santa rolls out DE&I initiatives for the reindeer. All the other reindeer claim that Rudolph is getting special treatment because of his red nose, and they want the opportunity to lead the sleigh as well. What should Santa do? A, cancel all DE&I programming. B, tell the reindeer to take a hike. C, ensure DE&I initiatives do not engage in impermissible discrimination. Or D, just let the elves fly the sleigh. So we'll give everybody a few seconds to get your answers in before we move on to our next topic. Okay, got some coming in. All right, so it looks like almost everybody answered C, 93.9%, which is the right answer. Yeah, make sure that your DE&I programs do not engage in impermissible discrimination. That was kind of a softball we threw you guys there. So with that, we'll transition over to our final topic. Rufino Gaitan is a labor and employment lawyer in our Houston office. He is going to talk a little bit about recent developments at the National Labor Relations Board. Rufino has significant experience representing clients in labor matters, including collective bargaining, labor arbitrations, unfair labor practice claims, and union election petitions. And he's represented numerous clients before the National Labor Relations Board. So with that, I'll turn it over to Rufino.
Hi, thanks, Kevin, for the introduction, and thank you, everyone, for joining us today. I think Kevin decided to torture everybody by finishing with a topic that probably isn't going to, make me a big fan of anyone in the audience. But the NLRB has, during the Biden administration, really taken to heart the president's directive and promise, really, to unions that he is going to be the most pro-labor president in American history. And, he really has tried to live up to that promise. And because the NLRB is an agency of the executive branch with members appointed by the president, those board members are essentially doing what the president's agenda has been all along, which is to become a very pro-labor, pro-employee administration. And so the most recent iteration or version of this pro-labor administration has been through the issuance of a new rule defining what it means to be a joint employer. And the rule itself the final rule was issued in October. The effective date was originally supposed to be December 26th as sort of a holiday present for all employers. And then the board decided to postpone the effective date due to some ongoing litigation, with the hope that that litigation is resolved. The new deadline for the effective date, or the effective date, would be February 26th of 2024. The one thing to remember here in terms of timing is that that new rule will only apply to cases that are filed on or after the effective date. So assuming the date remains, in February, then that will be the sort of the cutoff between the old standard or the current standard and the new one. If the rule happens to be postponed any further, or if there's an injunction, that halts the implementation of it, then obviously that will trigger further delays as well. So in short, this new joint employer rule says that status, the joint employer status, is going to apply to any entity that has an employment relationship with the workers at issue. And if that entity shares or co-determines one or more of the essential terms and conditions of employment. So what do those essential terms and conditions of employment mean? You have here on the screen a list of what those things are. The first one is pretty obvious: wages, benefits, other compensation, hours of work, and scheduling. These are all fairly standard things that tend to define what it means to be an employee. If you are setting these conditions or terms and conditions of employment, then in all likelihood you are exercising some level of control over the work relationship with that individual. The assignment of duties to be performed, the supervision, so obviously the method or control over how that work is performed is going to be a factor as well. But the sort of silver lining, I guess, if there is one here, is that this list that you see on the screen is an exhaustive list. So if the term or condition of the work to be performed is not actually something that falls within these categories, it is not relevant to the analysis of the joint employer status. That said, and why this is very important, is in terms of what the current standard is. The current standard requires a putative joint employer to possess and exercise substantial, direct, and immediate control over the terms and conditions of that person's employment. And the reason that is important is that if you are in if your entity is in a contractual relationship with another entity that is providing workers for a particular purpose, if your contract with that third party doesn't currently reserve the right for your organization to control any of those aspects, then that's one of the key components here, right? So you've reserved the right, or you didn't reserve the right to control the work. On top of that, you would have to also exercise some of those powers that you've retained, right? So you've retained the right to control, and you actually exercise the right to control. Whether you do it directly or indirectly is another factor that goes into that analysis. With the new rule, however, the authority to control the essential terms and conditions of employment is going to be determinative regardless of whether you actually exercise any of those rights. So for example, most employers, when they do retain third parties to hire outside help, essentially, usually try to maintain some level of control over what how the work might be delivered. It might be that you're saying the work has to be performed at a certain time of the day. There are limitations on how those workers can perform those tasks. If you've retained any of those rights in that contract, even if you've never actually enforced them or tried to enforce them or engaged in even indirect communications with that third party about one of their workers not doing things properly or according to your standards, that is also going to be determinative of the joint employer status here, because you've retained the right, even if you've never actually made use of those rights that you retained contractually. So again, why should you care? When we look at the types of scenarios where any employer is engaging third parties to provide certain types of work, we see this a lot in the construction industry. It's certainly going to be a big concern for general contractors who are retaining subcontractors to do certain work. Again, depending on what those contractual relationships look like, that's going to be a factor to consider once the rule goes into effect. Have you retained the right to control or dictate any of those essential terms and conditions of employment? And if you have, even if you have no intention of ever exercising those rights, that is going to be something that puts you at risk of becoming a joint employer with that other third party. And it might, for example, if those employees decide to unionize, you might be forced into a situation where you will be required to bargain with that union over any term and condition of employment that you've actually retained the right to control. So that is the risk. It is certainly something to consider. I would urge you to, if you do have contracts already in place with third-party organizations where you're retaining that type of contractual right, you want to at least reconsider whether you want to retain that right at all. And if you do, you should do it knowing that this is going to be one of the risks of keeping that right in those contracts with third parties. One thing that I want to make sure I cover here is when we're talking about this new joint employer rule, it is its reach is intended, at least initially, to apply to the collective bargaining aspects of the relationship, right? So again, if that third-party workforce is unionized or becomes unionized during the time period when you are engaging with them, you could be forced to bargain with that union. It is unclear from the rule. The rule doesn't actually cover the joint employer aspect in a term or in issues that are beyond that collective bargaining process. So what I mean by that is if one of those third-party employees files a charge, an unfair labor practice charge with the board against their actual employer, but let's say that you as the third party had a hand in addressing any of the issues that led to that unfair labor practice charge, it's unclear whether the board is going to try to expand the reach of that joint employer rule to address these unfair labor practice scenarios, or whether it's really going to try to limit them to just the bargaining aspect. So again, just something to consider and keep in mind as you negotiate new deals or new contracts with third parties to provide certain services for your organization. Again, in the construction industry, this is going to be a big issue. It can be a big issue in the healthcare industry as well, especially for those employers who contract cleaning services is another big area, right? So janitorial services, where the main entity no longer wants to employ those individuals directly, so they hire a third-party service. You have to just be very mindful of the terms of your actual contract with that service provider. And again, going into that scenario with open eyes, at least understanding what it means to retain the right to set or in any way influence really an essential term or condition of that worker's employment. So that is the joint employer issue sort of in a nutshell. And obviously, if you've got questions, we'll be happy to address them and respond to them in the chat. But there are a couple of other issues that are equally as important, if not even more troubling, because you really have even less control in some of these scenarios. So I've listed on your screen 3 different cases that have been decided by the NLRB this year. The first one is CEMEX construction material specific. And the question that I pose here is, who needs elections, right? This case addresses a scenario that really has fundamentally overhauled how employers, unions, and employees go about the process of selecting or challenging a collective bargaining representative. The current state of the law is that not the current state, the prior state of the law is if you received a request from a union business agent as the employer, they present you with a collection of authorization cards signed by your employees. They tell you, hey, I have, of this bargaining unit that we want to organize and unionize, we've received 60% of those bargaining unit employees have signed these authorization cards. We're demanding that you voluntarily recognize us as the collective bargaining agent. Voluntary recognition in the old scheme was essentially a way for the union to avoid an election altogether. The employer had the option to recognize the union voluntarily, in which case they start collective bargaining, or tell the union, thanks but no thanks. If you want to be the collective bargaining representative for our employees, we're going to ask you to go file a union election petition with the board, and let's put this to a vote. Let's let our employees make that decision in the safety of a secret ballot election that is conducted by the National Labor Relations Board. What the CEMEX decision has done is it's sort of turned that process on its head. Now, according to the board, in the scenario where a union presents an employer with a claim that they've achieved majority status from the bargaining unit that they seek to represent, the employer still has the option, although whether it's really an option, I'll leave it to you to decide after you hear this, but you have the option of agreeing to voluntarily recognize, in which case no election is needed because the parties agree, there's majority support, and you engage in bargaining. However, what the board has done now is they've said, if you choose as the employer to say thanks but no thanks, you now have just 2 weeks to file your own election petition with the board. And these petitions are called representation management petitions, or RM petitions. So now you have the burden of going to the board, to the regional office, filing that petition, and initiating that process. In the interim, and that's bad enough, but what the board has done and gone a step further is in saying, if during that process, after you file that petition for an election, to try to give your employees a secret ballot election, if the union files an unfair labor practice charge and the board determines in its investigation that you committed some violation of the act, whether it's making promises to employees for benefits if they don't unionize, threatening them with termination or other adverse actions if they do choose to unionize, whatever the case might be, if you engage in any unfair labor practices, instead of holding an election, the board is going to dismiss your petition. And that's, again, bad enough, but it's going to then order you as the employer to bargain with that union without an election ever being held. It seems a little academic, especially if the union has legitimately gotten signed authorization cards from a majority of employees. However, what we never know as the employers or employer representatives is, well, what did the union do to actually get signatures on all those cards? There's a couple of things. One is coercion, right? So they coerce people into signing. Another is they misrepresent what it means to sign that authorization card. They might tell an employee, this doesn't mean you support the union. It only means that you are interested in learning more about what this process entails. That misrepresentation, the coercion, the sort of peer pressure that comes with another tactic, which is, coming to employees and telling them things like, hey, we've gotten, 56% or 60%, whatever number they throw out there, of people to sign the card. That may or may not be true. If you don't sign the card, we're going to send an email to all your coworkers telling them that you've decided not to sign. So the peer pressure and all these pressure tactics are coercive. They have a coercive effect. The board doesn't care. If the union says they've gotten the support of the majority of the employees, and you as the employer can't refute that, it's going to hold your feet to the fire, and it's going to force you down this other path that is much more perilous than the prior norms. So, and I apologize, I realize Halloween and the scare tactics were, last month's news, but I know that this is also just a pretty scary topic to think about, especially if any of you in the audience are currently, experiencing a union organizing drive, or you're concerned about these issues. Miller Plastics, the focus of this case is around the issue of what constitutes concerted activity. Under the NLRA, the only type of conduct that is protected under the Act is activity that is concerted in nature. It's usually for the mutual aid and protection of the employee and his or her coworkers. Here, in this particular case, it revolved around the COVID-19 pandemic. It was early on in that March of 2020 timeframe where the employer here, Miller Plastic, decided to stay open in mid-March. And during some all-employee meetings that they were having, as they were telling people, we're going to stay in business, we're going to stay open, you still have to come into work. During some of those meetings, an employee complained about why they were still having to come into work when there's this potential deadly virus floating around that we knew little about at the time. There was some controversy and dispute in the testimony about whether the employee said something to the effect of, why are we coming into work, or why are we still working? The employer, of course, challenged that employee's concern. The employee's eventually terminated, and he's terminated because he continued to be disruptive during working hours. He was talking to coworkers. He had previously been counseled about some of these issues. He did it again soon after the pandemic and after he had made that initial complaint, and he filed a charge because of that termination. The employer's position during the process was he wasn't really complaining about everybody else. This was more of a self-preservation type complaint that he was making. And the fact that he may have said, why are we still working, shouldn't be determinative. Under this administration, I've had numerous clients come to me and ask me, when an employee complains about things in a very vague manner, what is the risk of terminating that employee for being disruptive? And this is it, right? It's you terminate an employee for legitimate business reasons or performance issues, but they engage in what may or may not be concerted activity. That creates a risk of an unfair labor practice charge if you proceed with any form of discipline. Generally speaking, protected concerted activity is activity which is done either collectively, so in groups, or with the authorization of other coworkers, right, other people. So there's a joint aspect to that activity. Here, it was a single employee complaining in a group setting, sure, but not in a manner that really indicated that he was acting on behalf of others. This case, the Miller Plastic case, also, it essentially overturned a prior board decision that was issued during the Trump administration, which really focused on 5 different factors. And one of those factors was, did the employee do this at a meeting where the employer is talking about changes to the terms and conditions of employment? Did did the issue address and it said, a term of condition of employment? Was this an opportunity? Was this the first opportunity? Was this meeting the first opportunity where the employee had the ability to address that issue with the employer? There were several other factors that went into that consideration. Now the board is just saying, we have to treat this on a case-by-case basis. Those factors under the prior case was a case called All-State Maintenance. Those factors were too limiting, and we can't limit what constitutes protected concerted activity. We have to address issues on a case-by-case basis. All that to say, if you have a similar scenario, think very carefully about when the employee engaged in the activity that's at issue, what was the actual substance of the employee's communication to you? Is there really any likelihood that the employee is complaining about something that only affects him or her, or is he or she complaining about something that affects a broader pool of employees? If there's any chance that it's a broader pool of employees under this new standard, it's very likely that the employee has engaged in concerted activity, even though the real gist of the complaint might only be personal in nature. So again, another complication for employers, one that makes it much more difficult for you to manage employees and employee disruptions that can be framed in a protected concerted activity manner. And then finally, the last case on the slide is American Federation of Children. The issue here is advocacy for non-employees is protected, right? So it's not really a question. It's more of an outrage. This case dealt with an employee who speaks out to her employer, American Federation for Children, and says, hey, I know that this former employee who no longer works here wants to come work here again. Why don't you just rehire them, sponsor their visa? The employee required visa sponsorship to be able to continue working, sponsor their visa and rehire them. And of course, that leads to that employee becoming more disruptive when the employer tells them that they don't want to go through that pathway again. And eventually the employee is disciplined and files a charge. The employer's defense here was, this employee isn't even advocating on behalf of a current employee. They're talking about a former employee. They have no protection under the act. This is not concerted. It's, it doesn't relate to current employees not protected under the act. So the board looks at the issue and comes up with this sort of theory about that it refers to as the solidarity principle. And it looks at the employee's speech and it essentially says, what is it about this situation that can be concerted or protected? And it says, well, this employee is engaging in support of a non-employee, and in return, down the road at some point, maybe this employee or other employees will benefit from improving the working conditions. Or alternatively, they create support by supporting others, even though they're non-employees. They create goodwill with non-employees, and eventually those non-employees might also come to their aid whenever they actually need some help in their workplace. It's kind of a preposterous principle. It's one that is very speculative. The board actually used the word potentially in its decision. So it's not even a concrete issue that is realistic here. That said, I wanted to flag the case for all of you because I know that in a lot of your workplaces, and in particular healthcare settings, nurses, I'm married to a nurse. I know they care a lot about their job. They care a lot about their patients. Does patient advocacy at some point cross into this line as well? Does advocacy for the clients or people that you serve as an organization, even though it has no impact on how much the employee earns on an hourly or salary basis, it doesn't affect their hours of work, their terms and conditions. Is it possible that the board stretches this concept of this solidarity principle to include things like patient advocacy or advocacy for children that you might serve as a nonprofit organization, or any of those other things that you might do that really have no relationship to the actual work or the terms and conditions of the employee's employment. So with that level of scariness, I will turn it back to Kevin for signing off. Thank you very much.
Thanks, Rufino. Yeah, it's always fascinating for me to hear you talk about what's going on at the board, because I just feel like there's always something, and it's just always something that seems a little bit, at least from somebody who represents employers, typically a little bit out there. So that's the conclusion of our program. We do have one final poll question for you guys. I think it's pulled up on the screen. So the elves at the North Pole are complaining about Santa and the low wages they're paid, with one such elf getting fired. The elf then files a board charge and a union election petition against both the employer, Making Toys LLC, and Santa Claus, alleging that Santa is a joint employer because he exercises control over their work hours and their pay. Will the board find Santa to be a joint employer? A, of course, the board is known to be anti-Santa. B, it depends on whether Santa is exercising direct or indirect control. C, it depends on when the charge is filed and whether the new joint employer rule has gone into effect. Or D, both B and C. So we'll give you guys a few minutes to chime in with your answers while we get ready to wrap things up. And we've got some filtering in. Okay, a few more. I think this may be one of those that there's not a consensus on. Well, no, there is a consensus, actually. It looks like the majority of you guys, 63%, chose D, both B and C, which is the right answer. So with that, thank you all for joining us today. We hope that the information that we provided is helpful to both you and your organizations. As a reminder, this program has been approved for HR and legal education hours. To report those hours, go ahead and click that CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, again, along with a copy of the recording, so you can go back and watch it or share it with others if you like. And please, we'd also just ask again that you complete the short survey at the end of the seminar, because we do value that feedback, and we're going to use it to plan future programming like this. So that concludes our program. Thank you all so much for your time and attention, and have a good rest of your day.